Good day to you and welcome to another Paddocks Club video tutorial. Today I want to talk about owner buildings on common property without trustee or owner consent, give you a quick case study and then go through the principles. This arises from a question asked by Jacques Blanche. And what Jacques said was one owner in a complex has erected a small wall 1 meter high by 2.5 meters long in his driveway. That is on common property. He claims that this is a non-luxurious improvement as it channels water away from his unit. Other owners argue that it is purely luxurious, as he merely erected the wall for cosmetic purposes and to have an area against which he could put his unit number. Jacques continues, I understand that a luxurious improvement requires a unanimous resolution and a non-luxurious improvement requires a special resolution. So who decides on whether an improvement is luxurious or non-luxurious? Can I have the members at the special meeting decide about this before they vote in favour or against the improvement? Well, firstly, let's just look at this whole issue of luxurious or non-luxurious. It's a red herring in this particular instance. It's simply not relevant. Whether something is luxurious or not, and that whole distinction only applies in the context of Prescribed Management Rule 33, where the trustees initiate improvements that are to be paid for by the body corporate. And Jacques is quite right. In those situations where the body corporate will pay, if it's to be luxurious, if it is luxurious, then all owners must agree by way of a unanimous resolution, and if it's non-luxurious, then any owner can ask for a meeting, and at that meeting, the trustees can only go ahead if they can get support of a special resolution, which of course might not be 75% in number and value of the whole body corporate, but only of those who turn up. So the principles are right, but misplaced in this particular inquiry. When an owner builds something on the common property, or wants to do so, the first question you ask is, well, are you talking about an exclusive use area or not? Because if you are, then with the prior consent of the trustees, an owner can erect a building improvement on his or her exclusive use area, as long, of course, as it is not an extension of an existing section or a brand new section. In that case, then the trustees don't have the power to give consent. But assuming that's not the thing, then the trustees can give consent. And that, of course, this should be given before the building is erected. But in theory, it could also be given on an ex post facto basis, rather than making the person break the thing down. But let's move on to the situation where it's not within an exclusive use area. Now your question is slightly different. Was there prior consent from all owners? Because here, there's nothing in the prescribed management rules or in the Act itself that allows an owner simply to go and build on the common property. You know the common property is owned by all owners in undivided shares. And the common law, which applies in this instance, is that then all owners must consent because their property is being changed. It's not property that's subject to various rights, which could allow somebody to build with perhaps the trustee's consent. Prescribed Management Rule 4 is sometimes a bit of a devil in this situation. It actually provides that an owner or occupier of a section shall not mark, paint, drive nails or screws or the like into or otherwise damage or alter any part of the common property without first obtaining the written consent of the trustees. And it goes on to make an exception in the case of locking devices, burglar bars, safety devices such as gates, and also screens or other devices designed to prevent the entry of animals or insects into a section. In that case, the trustees can approve the nature of a particular device and thereafter all owners can install that type of device. But the fundamental principle in PMR 4 is not that trustees can allow people to make changes to the common property, it's that owners and occupiers must not do that unless and in very, very narrow circumstances, they can with the consent of the trustees. But what are those narrow circumstances? They're described as marking, painting, driving nails or screws into. So this is the sort of thing that might cover the attachment of a satellite dish, but could not cover something like the building of a wall. So in this instance, we have somebody who builds a wall in an area that's not an exclusive use area. The short answer is the trustees can't approve it, and only all owners could agree to it. And it wouldn't make any sense to do that other than perhaps in the context of giving the person exclusive use rights, because that then would mean that the costs of maintaining that particular thing are vest and are recoverable from the owner. If you don't make the area subject to exclusive use rights, then whatever they put, the bird bath, whatever they put up, it becomes ordinary common property. It's unregulated in every sense, so the common property, like all other common property, the body corporate would have to maintain it, which isn't what we're looking for in a situation where the initiative to build this thing comes from a particular owner, and one can assume that it will almost always be there only for that person's benefit. Well, except that might change in certain circumstances. If you have any questions, let's discuss them in the discussion forum.